It's easy to miss if you're not paying attention. Buried in the legal filings, past the headlines about inflation and Congress, there exists a document that most people will never see. A subpoena. Simple word. Straightforward legal instrument. But here's what most people don't understand. This particular subpoena represents something far more significant than the routine paperwork it appears to be. The Department of Justice, operating with what sources indicate is careful deliberation, has filed a subpoena that goes to the heart of a question that has haunted American politics for nearly 2 years now. What exactly happened? And more importantly, what evidence exists that could reshape not one, but multiple legal proceedings that are still very much in motion? On the surface, it looks like bureaucracy, standard procedure, the kind of thing that happens thousands of times a year in courtrooms across this country. But analysts, former prosecutors, and seasoned observers of the legal system understand something crucial. The timing, the specificity, and the breadth of this particular request tells us something about where the Justice Department believes its investigation stands. We live in an era where information moves at the speed of social media, where every filing, every tweet, every statement is dissected within minutes by armies of commentators with competing agendas. Yet this moment, this quiet, methodical step by federal prosecutors suggests something different. This is the work of people operating in the traditional lanes of law enforcement. Slow, measured, deliberate. The subpoena itself doesn't prove anything. That's not how the law works. But what it signals, and this is what most observers are missing, is that the Department of Justice is still actively pursuing lines of inquiry that many assumed had been settled or abandoned. The question now is simple. What do they know? And more importantly, what are they about to find out? To understand what's happening, you have to understand how these prosecutions actually work. The indictments that have been filed, there are multiple ones, in multiple jurisdictions, involving multiple legal theories, are not independent. They're connected. They share witnesses. They share evidence. They build on each other. What this subpoena does, according to legal analysts who study these matters closely, is it opens a new evidentiary pathway. It targets documents and communications that haven't been previously subpoenaed. Reports indicate this request focuses on activities and interactions during a specific and critical time period. The kind of period where decisions were being made, where conversations were happening, where plans were being formulated, or, alternatively, where awareness of wrongdoing was being deliberately obscured. Former federal prosecutors have noted that the breadth of this subpoena is significant. It's not narrow. It's not targeted at a single individual or a single transaction. It casts a wide net, and that matters because it tells us something about the confidence level of the prosecutors involved. They're not fishing. They're following a trail that apparently leads in multiple directions simultaneously. The legal architecture here is worth understanding. When you have indictments in multiple venues, and we do, you also have multiple teams of prosecutors working somewhat independently, though in coordination. When those teams all seem to be pursuing similar lines of inquiry at roughly the same time, that's when things begin to accelerate. That's when the pieces start connecting in ways that become difficult to manage or contain. What we're seeing, according to sources familiar with the investigation, is a coordinated effort to establish a more complete evidentiary record. Not just about one event, not just about one decision, but about the broader context in which events unfolded. And context in law matters enormously. It can transform a he said, she said dispute into something far more definitive. It can take circumstantial evidence and weave it into a coherent narrative that a jury can understand and evaluate. That's what prosecutors are building toward. Not headlines, not political theater. A case, a narrative, a record that can withstand scrutiny. Here's what most people don't grasp about the criminal justice system. When you have multiple prosecutions, multiple grand juries, multiple courtrooms, all pursuing related matters, they don't exist in isolation. They echo. They influence each other. A discovery in one case can reshape the entire landscape of another. The subpoena we're discussing has the potential to create what legal scholars call a cascade effect. Imagine dominoes, if you will. One piece of evidence discovered through this subpoena could lead to follow-up questions. Follow-up questions lead to additional subpoenas. Additional subpoenas lead to new documents. New documents can refresh memories. Refreshed memories lead to changed stories. Changed stories particularly when they're offered under oath, become a very serious problem for anyone who is betting on consistency. There are currently indictments pending in different courts. Some involve financial matters. Some involve classified information. Some involve constitutional questions about the peaceful transfer of power. They are linked by certain common threads, people involved in multiple cases, timelines that overlap, decisions made in one domain that had cascading consequences in others. If this subpoena produces evidence that clarifies the relationships between these threads, suddenly the prosecutors in each of these cases have new leverage, new context, new ways to approach witness interviews, new angles to explore with grand juries. Consider also the witness dimension. There are individuals who have been indicted in certain cases. Those individuals presumably know things. What they know and what they're willing to reveal depends partly on their assessment of their legal exposure. If new evidence emerges that makes their position more precarious, if documents surface that contradict their previous statements, suddenly their calculus changes. A person facing significant prison time often becomes cooperative when confronted with overwhelming evidence. This is not speculation. This is how these prosecutions work. It's how the system functions. One piece of evidence, properly deployed, can reshape an entire case. And when you have multiple cases all building on interconnected facts, a single new evidentiary development can send reverberations through the entire structure. That's what legal analysts are watching for. Not just what the subpoena produces, but what that production will mean for everything else that's still pending. We don't like to admit it, but the law is never purely about law. It's also about politics. Not in a corrupt sense, though that concern does linger, but in the sense that political realities shape how institutions function. And right now, those political realities are extraordinarily complex. You have a significant portion of the country that views these prosecutions as legitimate exercises of law enforcement. You have another significant portion that views them as political weaponization. You have a Congress that is divided. You have a media landscape that is fractured. And you have a Justice Department that is trying to navigate all of this while maintaining the appearance and hopefully the reality of institutional independence. The timing of this subpoena is instructive. Reports indicate it comes at a moment when certain strategic questions are being asked in various quarters. What is the realistic timeline for resolution of these cases? What is the likelihood of conviction? What are the political consequences of various outcomes? These are the conversations happening in back rooms, in secure phone lines, in closed-door meetings. The subpoena suggests that the Justice Department believes it still has significant work to do. That conviction is not assured, but neither is it impossible. That there are evidentiary gaps that need to be filled. That the record, as it currently stands, is incomplete. For anyone connected to the matters under investigation, this is deeply consequential. It means the investigation is not winding down. It means new pressure points could emerge. It means that cooperation or continued non-cooperation could soon become far more than an abstract ethical question. It could become a practical necessity with immediate legal consequences. There's also the question of what happens in Congress. Certain members have been making arguments about prosecutorial overreach. Those arguments depend partly on a narrative about the scope of the evidence and the legitimacy of the investigation. New evidence could reshape that narrative. They could make certain arguments untenable, or it could validate the concerns of critics. We simply don't know yet. What we do know is that the Justice Department is proceeding, methodically, carefully, not rapidly, but not hesitantly, with apparent confidence that the work it's doing is legally sound and that the evidence it's pursuing will matter. At some point, all of these threads converge. All of these cases, all of these investigations, all of these lines of inquiry reach a moment of reckoning. That moment may be months away, or it may be years away, but it's coming. And the actions being taken now, like this subpoena, are laying the groundwork for it. Legal experts point out that the government's burden is clear. It must prove guilt beyond a reasonable doubt. That's the standard. That's the constitutional requirement. Everything the Justice Department does in these investigations must be measured against that standard. Every piece of evidence must be evaluated in that context. What this subpoena suggests is that prosecutors believe they are on a path toward that standard. They believe that additional evidence will strengthen their position, or they believe that the evidence they discover will answer critical questions that remain unresolved. There's also the human element to consider. People are involved in these cases, people with families, with futures, with choices to make. Some of those people have remained silent. Some have cooperated. Some have fought. Their decisions and the information that informs those decisions will shape how these cases ultimately resolve. The convergence we're approaching involves legal decisions, judges ruling on motions, juries reaching verdicts, but it also involves human decisions. Decisions about how much risk to accept, decisions about whether the costs of continued resistance are worth the potential benefits, decisions made by individuals under extraordinary pressure, with enormous stakes, facing evidence they may not have anticipated. This is where prosecutions often turn. Not at the headline moments, but at the quiet moments, when someone confronts the reality of their situation. When someone recognizes that the evidence is more substantial than they hoped, when someone realizes that their best option may not be to fight, but to cooperate, the subpoena we're discussing could be the precursor to exactly that moment. It could signal that prosecutors are moving from the investigative phase to a phase where they're closing off remaining questions, where they're preparing for the endgame, where they're building a record that can withstand whatever defense will be mounted. So what happens next? That's the question everyone is asking. And the honest answer is that the immediate consequences will likely be quiet. There won't be dramatic headlines for a while. There will be responses to the subpoena. There will be negotiation about the scope of what must be produced. There will be legal arguments about privilege and relevance. There will be delay, as there always is in the law. But beneath the surface, things are moving. Prosecutors will receive whatever documents are produced. They'll analyze them. They'll compare them to existing evidence. They'll identify contradictions, confirm suspicions, or discover things they didn't expect. That analysis will inform their next moves. For anyone who has been subpoenaed, the clock is ticking. There's a deadline for response. That deadline will arrive, whether people want it to or not. And whatever choices they make about what to produce, how much to comply, what to fight those choices will have consequences. Some of those consequences are legal. Some are practical. Some are psychological. The broader political consequences will unfold more slowly. But they will unfold. If evidence emerges that validates the narratives of one side of this debate, you'll see movement in that direction. If evidence suggests problems with the prosecution's case, you'll see movement in that direction instead. Public opinion will shift. Congress will adjust its posture. The political landscape will reshape itself in response to information that emerges from courtrooms and legal proceedings. Most people don't realize this because most people don't pay careful attention to subpoenas and legal filings. They pay attention to trials, to verdicts, to dramatic moments. But the real work happens in the documents, in the filings, in the quiet, methodical pursuit of evidence. What this subpoena means, ultimately, is that we're still in a crucial phase of this entire process. We're not at the end. We're not even in the final stretch. We're in a moment where the outcome is still being shaped by the choices of prosecutors, judges, and individuals who are directly involved in these matters. The story is not over. In fact, if you understand what this subpoena actually represents, you understand that the most significant chapters may still be ahead. The decisions made in the coming months will echo for years. The evidence that emerges will reshape how history remembers this moment. And the reckoning that's coming will involve not just individuals in the dock, but institutions, processes, and the fundamental question of how justice operates in this country. Pay attention, because what's happening now in these quiet legal filings matters more than most people realize.